Worcester Corsetry Limited was essentially owned by two family groups, the Wittings, who had the majority interest, and the Darks, who had the minority interest. At a company general meeting in 1932, the corporation resolved to appoint two members of the Witting family as directors of the company. It seems fairly clear from the context that the Witting family was in favour of this move and the Dark family was against it. The Dark family argued that the appointment of the directors by the general meeting was invalid because the company constitution included a provision which said the directors may from time to time appoint additional directors, but so that the total number of directors shall not exceed the prescribed maximum. The Darks argued that this provision had the effect of taking the appointment of directors away from the general meeting and investing that power in the board. Now, there was no doubt that a company has the power to delegate to the board the exclusive right to appoint board members. Indeed, their honours discussed an earlier case where this very thing had been done. However, their honours found that there is in each company an inherent power for a general meeting to appoint directors. For this power to be alienated or taken away from the general meeting would require very clear words. Lord Justice Lawrence put it this way: the company has an inherent power to nominate and appoint its own directors unless that is in any way restricted by the contract contained in the Articles of Association. Unless you can find that that inherent power has been handed over by the company to the directors, I think they retain that power as a natural result of their having the power to increase their board of directors. This case stands as authority for a number of propositions. First, that a company, through a general meeting, has an inherent power to appoint directors. Second, that the company can delegate that power to the board so that the board can appoint directors. Third, that such a delegation can either be exclusive, so that the company general meeting can no longer appoint directors, or it can be concurrent, so that both the board and the general meeting can appoint directors. Finally, that if the power to appoint directors is delegated to the board exclusively, there must be very clear words to do so.